Hello, my name is Brian DiPaolo, and I'm the Director of Strategic Services at Accudata Systems. As most of you are aware by your attendance, today is the deadline for General Data Protection Regulation Compliance, otherwise referred to as GDPR. I want to thank you for joining us and welcome to our webinar. If you're not compliant, you're behind. These are the 7 steps to GDPR compliance. Before we get started this morning, just a couple of housekeeping items. First, we will have a live Q&A session at the conclusion of today's webinar. Please feel free to ask your questions in the chat window in your browser. After the webinar, each attendee will receive a post-webinar email with our recorded webinar and a copy of today's presentation. Your hosts today are Accudata Systems and ForcePoint. Headquartered in Houston, Texas, Accudata Systems is a leader of IT consulting, cybersecurity, and systems integration. For over 35 years, we've helped organizations solve their toughest IT challenges based on our 3 core pillars: secure, modernize, and grow. Accudata has successfully partnered with ForcePoint for over 10 years. ForcePoint is a global leader in cybersecurity solutions with a unique approach focused on understanding human behavior and the intent to protect employees, business data, and intellectual property. So at this time, I'd like to introduce today's speaker, Paul Kendall. Paul is an advisory services principal in our risk and compliance practice at Accudata Systems, providing high-level consulting services to our customers in IT security, regulatory compliance, and information security management. Paul has over 40 years experience in healthcare, financial services, and manufacturing fields. During his career, Paul has successfully built several information security programs from the ground up for both Fortune 500 and global companies, as well as managed existing programs in the United States, the United Kingdom, and France. Paul, thank you for joining us today. Without further delay, I'll turn this over to Paul to get us started.
Thank you, Brian. Unfortunately, the length of today's presentation includes a real in-depth dive into this topic. And I got to tell you, that's probably just as well. We could spend a lot of hours wading through all the details and opinions that make up GDPR. I would imagine, though, that everyone here probably agrees that this is an incredibly complex set of regulations to wade through, and there are many potential paths to compliance. Based on our prior engagement work with GDPR, Accudata developed a 7-step process to assist companies in attaining GDPR compliance. This process groups functional components into major phases, allowing for faster consolidation of information, creating an integrated approach to compliance. This approach allows us to maximize our organizational and technical expertise across our company to best assist the client in achieving their GDPR compliance goals. Accudata has partnered with ForcePoint using several of its products to assist clients in managing many aspects of their IT environment. ForcePoint's DLP, data loss prevention, and other solutions are valuable tools in helping companies attain and, more importantly, maintain GDPR compliance. So today's the day. This has been a pretty big global game changer for privacy, and we've still got a lot of people who are behind. In April 2018, Crowd Research Partners issued its GDPR report, in which it found that up to 93% of companies surveyed may miss the compliance enforcement deadline, with 60% of those surveyed certain they will miss the deadline. Some examples of companies choosing to cut off their EU pipeline rather than try to work on this while still maintaining EU contacts: companies like Instapaper, which is a bookmarking service owned by Pinterest. It shuttered its EU operations at midnight last night. Additionally, as some of you may have seen this morning, newspapers like the Chicago Tribune, Los Angeles Times, Arizona Daily Star, New York Daily News, and others all cut off their readership in the EU at midnight due to noncompliance. Real briefly, let's go over some of the terms we'll be using in this presentation. First and foremost, what is a data subject? According to GDPR, this is an identifiable natural person, in other words, not a company or not a made-up name or anything, who can be identified directly or indirectly, in particular by reference to an identifier, things like name, address, Social Security or national ID number, etc. This is not necessarily a citizen of the EU, but only has to be in the EU at the time the request was made. So if a U.S. citizen is in Paris and uses a French website to make a purchase, GDPR applies to that individual at that point in time. Supervisory authorities. These are the independent public authorities established by an EU member state who are charged with enforcement. In the U.S., this role will be fulfilled by the Federal Trade Commission. Data controller is a natural or legal person, public authority, agency, or other body which alone or in conjunction with others determines the purposes and means of the processing of the personal data that they have gathered. Data processor, much the same, except they are pretty much limited to being able to process personal data on the behalf of the controller. In other words, they don't make up the rules, they process according to the rules that the controller has provided. So yes, today is D-Day for GDPR compliance. And to celebrate, noyb.eu, which is an EU digital rights group, has filed 4 complaints against Google Android, Facebook, WhatsApp, and Instagram over forced consent. Facebook suit was filed in Austria, Instagram in Belgium, WhatsApp in Germany, and Google was filed in France. Total potential fines in these cases could amount to almost 8 billion euros, or about $9.2 billion in U.S. Now, I think most everybody knows about the 2-tiered fine structure, 2% of gross annual revenue or 10 million euros, up to 4% or 20 million euros, whichever is greater. And some companies in the U.S. have asked, well, how are they going to enforce this against us if we just refuse to pay the fines? Actually, fairly simply, the EU regulators rely on international law to issue fines. We don't really yet have an EU-US negotiated civil enforcement mechanism for GDPR, but there is still the application of international law and the cooperation agreements between the U.S. Federal Trade Commission and EU law enforcement agencies. In addition, under GDPR, individuals may bring judicial redress against companies, with the potential for huge legal entanglements. Finally, in a global market, reputational damage is very highly likely. So, what do? Well, panic might come to mind given that enforcement's already begun, but it's still probably not in your best interest. Panic is really not an option here. So in the next few slides, we will discuss these critical 7 steps you should take to meet GDPR compliance within your organization. First one is really understanding the requirements. This is one of the most important things you can do. There tend to be some complexities in the requirements, and so making sure that you have a clear understanding of what the requirements and responsibilities are as a controller and or a processor become very important. This includes, of course, organizational and technical compliance because there are both components to GDPR. Awareness and staff training. GDPR is really a new model when it comes to data protection. So it's very important that all your employees be on the same page with their understanding. Executive management in particular must be aware of their roles and responsibilities with regard to GDPR compliance, and they must be prepared to lead by example to ensure there is a uniform approach. Appointing the data protection officer or lead, as defined in Article 37 of the GDPR. DPO may or may not be required. It kind of depends on the nature of the processing that you're doing. In some cases, though, a DPO is mandatory, particularly if the company handles human resources data or if your processing operations involve regular and systematic monitoring of subjects on a large scale. Again, think Facebook and Google, one of the reasons that they're leading off in the suit battle today. So in those cases, DPO role is really mandatory. Each EU country, in addition, may also specify when a DPO is required. Germany requires any company with 10 plus employees that processes personal data to have a data protection officer. So in addition to GDPR, you also need to look at the individual EU member states' requirements for some of these issues as well. In any event, it's a good idea to bring someone on board, even if it's in a contractual capacity, to oversee the compliance implementation. One of the product offerings or service offerings that AccuData offers is contractual DPO services to assist their clients in moving forward with GDPR compliance on a project management basis. Finally, having a governance structure in place is going to be critical. An appropriate governance structure should be established to ensure that you've got the right engagement with the right people at each stage of the program. And again, this is something that the executives really have to be involved with and lead by example on. Without this accountability and responsibility driving the process, it will be difficult to attain compliance. Next, you have to determine exactly what it is you have. You need to perform an information audit for starts, mapping all your data throughout the organization, which is probably one of the singularly most difficult tasks to accomplish. Mapping this data and how it flows through the organization really is a critical first step to understanding how to protect the data and to fulfill data subject access requests. And the data can be anywhere. It can be in your servers. It can be in your backups. It can be on desktops, laptops, mobile devices. So everywhere that data exists, you should have a certain knowledge of who has it, what it is, and what they're doing with it. You need to record all of the processing activities, anything that is done to the data while it's in your custody. Article 30 of GDPR requires that certain organizations maintain records of their processing activities. In other words, here's a piece of data, here's all the processing that we do on it through the life of that data in our organization. This is mandatory for firms with more than 250 employees, and in certain cases, it's mandatory for those with fewer than 250 employees. And again, individual member states may set some of their own parameters on this as well. So keeping a record of these processing activities documents the purposes for processing. It describes the categories of personal data, which is going to be important from a risk assessment standpoint. It details when data is disclosed, who it's transferred to, and makes sure that it identifies any time limits for the erasing of personal data. So it's a fairly complex record of what all the processing in your organization is doing and the data that it's being done to. The end goal, of course, is to just create and maintain a processing activities register for all the activities involving personal data that must be managed under GDPR. This becomes important when you start looking at data subject access requests. Performing a data protection impact assessment, or a DPIA. This is really a systematic description of the processing operations and the purposes of the processing, but it's also an assessment of the necessity and proportionality of the processing. GDPR mandates that processing be done with the absolute minimum amount of data that is required to perform the task. And so this assessment measures necessity and proportionality, but it also helps identify risk to data subjects and the measures that are employed to address those risks, both from a technical and an organizational standpoint. Review existing data protection processes. This is your IT security group, your risk management team, other people who are responsible for the security and the risk management and governance of data within the organization. You need to review the current technologies that are in place, both in terms of hardware and applications, and define the current protection environment, establish the baseline for understanding where the gaps in compliance exist. This will be important in beginning to build your data protection program as you go forward. AccuData offers several different aspects to this. We have what we call a gap assessment engagement, which basically works to identify the data locations, perform some data mapping and inventory, and help with the data protection process identification and documentation. In addition, ForcePoint's data loss prevention product is really a valuable tool in this because it's able to identify personally identifiable information in both structured and unstructured formats and environments. This includes personal data contained within images. ForcePoint's predefined policy library can identify PII across a span of 190 languages, making it very useful for GDPR compliance purposes. And it does this using a combination of content, context, and lexical analysis to identify personally identifiable information. ForcePoint DLP may also be used to manage and control personal data flows. This will help protect your PII from loss or use by giving you a clear definition of what these data flows are and how the data is being used. You need to establish the legal use for your data. First thing is a legal, what we call a legal use basis. This determines how you're going to be processing the data. And there are 6 different areas where this falls into. You can process data based on consent. This is the one that a lot of people have been seeing, and you probably have been getting a lot of emails from your business partners wanting you to consent to their privacy policy again. It's basically where the data subject gives consent to the processing for one or more specific purposes. It's probably one of the ones that's the most rigid in terms of application. Others include things like contracts. If you have to maintain the data for a performance of a contract to which the data subject is party to, or if it has to be done prior to entering into a contract, then at that point you have a legal basis for maintaining that data. If the controller, this is the person who's collecting the data and maybe processing it or maybe sending it off to a processor, has any legal obligations that they have to comply with. Examples of this in the U.S. would be IRS rules, SEC rules, human resources rules, etc. Vital interests. This is essentially protecting the vital interests of the data subject or another person. So any kind of relationships there. And they're kind of fuzzy on exactly what vital interests are, but anything that's of importance to the individual that the controller has some responsibility for managing would probably fall under the vital interests area of this. In some cases, you may need the data for performance of a public task. This is something carried out in the public interest. Or has some sort of official authority vested in the controller to perform it. This would be things like, well, in the U.S., voter registration records, where you don't necessarily have to have a consent to carry that information because it is used in the carrying out of public tasks in the public interest. And finally, one that's probably gotten the second most amount of interest generated are things called legitimate interests. These are the interests that you as a controller are pursuing and require the use of some of that personal data to perform. Now, it is subject to some limitations, and several of the articles in GDPR do talk about this. So it'd be very important to go look at those specific articles and the accompanying recitals to determine exactly how legitimate interests should be interpreted in your case. Should be reviewing your existing privacy notices. This is what you've been getting in the mail for the past week. You've got to have a privacy notice in place, offers GDPR information disclosures. This thing can't be buried in an end-user license agreement like so many of them have been in the past, or any other document. It really must be standalone. It must be in plain language, not in legalese, and it must allow the subject to explicitly opt in. It says no more opt-out. Data subject really has to positively affirm consent. Checkbox, for example. And over the past 2 days, I've received 3 or 4 of these consent forms where right down at the bottom it says, if you do nothing, we will continue to use your data. That's not opt-in. That's that kind of implicit opt-in. and you cannot do that under GDPR. And so, and several that I've gotten from the EU, for example, they give you, go to this website, read this, click to opt in, and then you have to confirm that you clicked that to opt in. And so the physical opt-in process must be explicit, and you must be able to show that you positively did this, not that, for example, you just never read the email. At this point, you should begin to be building your data protection policy. You've got to have data protection policies and procedures in place to show technical compliance, certainly, but also the organizational measures that you're taking to comply with GDPR. In this case, ISO 27001 is a real good tool for this. A lot of GDPR can be mapped back to ISO 27001, which makes it an excellent candidate as a security framework for developing any GDPR security measures that you're looking at taking. Understanding data subject rights. Data subjects have a fairly extensive set of rights in the EU, and some of these can be kind of confusing. Subject access requests is a good starter. Data subject can obtain from a controller any kind of confirmation about whether or not personal data about them is being processed. So I can write essentially, as a resident of the EU, I could write any company in the world essentially and say, what data do you have about me and how are you using it? This goes back to the old Data Protection Act. It's just been retained and enhanced in GDPR. So this really isn't a whole lot of news to a lot of people. The rest of them came about as GDPR. We're going to dive into those in just a tad more detail. Subject rectification request. Data subject has the right, once they've determined what data you have as a controller, to correct any inaccurate personal data. And you as a controller are bound by GDPR to make those corrections. In some cases, you must make those corrections before processing can continue. What GDPR refers to as condition-based erasure requirement. Everybody else knows it as the right to be forgotten. Data subject has the right to obtain from the controller the erasure of all personal data concerning them in some instances. This is not an all-inclusive, but particularly when the data is no longer necessary for the purposes it was collected, or in the case of a consent form, the data subject withdraws request. In the case of the controller or in the case of the data subject, there are times where the data must be erased for compliance with a legal obligation. Right to be forgotten would fall into would play into that. What's relatively new about this is in the case where a controller has made that data public or has otherwise shared that data, they are now obliged under GDPR to inform those people that they sent that data to about the right to be forgotten request that they have received, and the processors who are using that data sent by the original controller are also obligated to perform that erasure. Now, the right to be forgotten is not an absolute right, as I mentioned a couple of minutes ago. There are some legal and contractual exclusions which do exist. So as controllers, you should really review Article 17 of GDPR again, recital 66, to understand what the rights and limitations of the right to be forgotten are. Data portability. This is the right for an individual to receive their personal data from a controller in a structured, commonly used and machine-readable format, comma-separated, text files, whatever, that can be easily read. And they have the right to ask you to transmit that to another controller. A real good example that I think everybody's familiar with is cell phones. If you go to a different carrier, in most cases, they'll be able to transfer the data from your phone over to their phone. And that's now a requirement under GDPR for them to be able to do that upon request. Data subject has the right to restrict the processing of personal data. you may have consent from a data subject to perform types A, B, and C processing of their data. Well, over time, you've developed enough information that now you want to do processes X, Y, and Z on. Well, you have to go back and get permission explicitly from the data subject. And the data subject can say, no, I don't want you doing X, Y, and Z. You can stick with A, B, and C. Now, if the data deals with direct marketing or some other limited activities, these are defined in Article 21 of GDPR, they can object to that processing and say, I do not want my data used for processing, particularly in these areas, if it's going to be for direct marketing or in some of the other activities as defined in Article 21. This is another one of the areas that's in the Facebook lawsuit, is the lack of any kind of right to object to processing. Managing data transfers. Data transfers are really only applicable if personal data is transferred outside of the EU. All of the EU member states are included in an interstate agreement that allows data to be transferred between them. Extra-state or outside of the EU transfers must comply with all GDPR regulations prior to the transfer taking place. In the U.S., some of that can be done under the EU-U.S. Privacy Shield, but beware, the EU is not very happy right now with the current government administration's take on data spying, and the Privacy Shield may actually be declared null and void in the next year or two if nothing changes. So U.S. Privacy Shield, not necessarily your best bet for a long-term strategy. So probably the best thing is to become GDPR compliant when you deal with data transfers. In addition, EU member states can further specify conditions and any additional restrictions for such transfer. And Germany's already done this. France is considering it. You imagine that over the next few months or years, every EU state will develop their own set of conditions around this. If you're using any subcontractors, make sure that they are GDPR compliant and that they follow all of the processing restrictions that you place on them as a subcontractor. Validating your security measures. So the technical and organizational measures, i.e. your security controls, your organizational controls, to protect GDPR within your environment. These fall under Articles 24 and 32 of GDPR, by the way. Start with your information security policies. Make sure that you've got your policies in place and that they cover all of the aspects of compliance. Again, ISO 27001 is a good starting point for achieving compliance in these areas. NIST may also be used. There has been some work done that does correlate NIST requirements to GDPR. And so if you're already working towards NIST standards, this may be a good bet for you in defining your overall security program. Make sure you have data retention and erasure policies in place, including mandatory retention and erasure requirements. These deal with a period for which personal data can be stored, as well as under what circumstances, conditions, or timeframes it must be erased from your systems. You should make sure that you have implemented procedures in place that validate all of the activities in your data processing, and that these should be done from the principle of data protection by what we call design and default. In other words, early in your design processes, data protection and security should be configured to be part of that design process. Installing new systems, make sure that data protection considerations are established in those systems by default. And these will be used to validate against or ensure compliance with GDPR. So we talked a little bit about data protection by design and default, and then earliest stages that data is processed by default to the securest level possible. This may, in fact, require some modification of your SDLC processes, such as Agile, to fully incorporate concepts of protection by design and default. Incident response, data breach management. If you don't have an incident response policy, get one. Incident response is going to be very critical in this because of the reporting time frames and other information that you're going to have to gather once you've had a breach of your data. So make sure you've got an incident response policy in place. Make sure that it covers the aspects of reporting for GDPR, and exercise it. An annual test is probably not enough. A test where you say, okay, we had a disk drive failure, what do you do? Does not really constitute an exercise. Exercises should fully test your incident response plan, and it should kind of throw some surprises in there so that it doesn't become just a rote exercise where everybody kind of regurgitates back the steps of the incident response plan. It's important to realize that in real-world scenarios, I've seen this many times, they never follow textbook cases. There's always a surprise or two in there. A real good example, if you want to look at response to an incident, is go back and watch the old Apollo 13 movie. Real good example of how you manage an incident response process with a lot of different failing components that catch you by surprise. Data breaches. Obviously, you have to document any personal data breaches and have your breach procedures in place. Processors must notify the controller immediately once a breach is discovered. Controllers must notify their supervisory authority within 72 hours of a breach discovery. In the U.S., the breach discovery reporting supervisory authority is the Federal Trade Commission, and they will notify the EU and local or federal law enforcement in accordance with that breach notification. Data can provide a lot of work around incident response. We've developed numerous incident response policies and plans for a variety of companies, ranging from single organizations to multi-department, multi-divisional companies. We really do develop a comprehensive approach to incident response, preparation through recovery and lessons learned. We do also work to provide test scenarios. If you want to run a test on your incident response plan, definitely something that we can assist you with. Our data breach process works closely with your company's legal department to ensure that the reporting processes are developed to align with the regulatory compliance reporting processes required for your organization. That includes state, federal, international, and any industry-required breach reporting. ForcePoint DLP can also play a part in the incident response through its detect, respond, and recover stages. These can be used in particularly the active recovery phase to ensure that you understand exactly how the personal data being processed may or may not be compromised. The Insider Threat module within ForcePoint does provide some behavioral analytics across all user and local machine activity. This does give you some deeper forensics content and includes things like video playback of desktop screenshots to speed up the investigation process. So in summary, obviously, first thing you need to do is understand the requirements. Get executive buy-in and corporate understanding for the requirement. This is critical. Without that, it becomes very hit or miss. Determine what you have. Do your information audits. Look at your processing. Document it all. It's going to be useful down the road. Establish your legal use basis. Make sure you've got the correct legal basis for processing, because the basis that you're using will determine how you have to obtain consent. Make sure you understand data subject rights, particularly those where they're requesting an action or information from you. If you decide to transfer data outside of the EU, make sure that all the GDPR requirements are in place prior to that transfer. EU-US Privacy Shield is accepted for now. We're not sure if it's going to be a long-term strategy yet or not. So GDPR still remains your best bet. Validate your security measures. Consider ISO 27001 as a validation framework. Provides probably the best mapping to GDPR that's currently out there. Make sure you have incident response and breach management processes in place, and make sure that those are tested on a regular basis. So if you still have concerns about GDPR, I mean, you're probably not alone in this, even though implementation day is here, or enforcement day is here. Certainly contact your account manager or ask to speak with one of our solution architects and a GDPR consultant about how AccuData can assist with these and other aspects of GDPR and or ISO 27001 compliance. And I'll turn it back over to Brian at this point.
Thanks, Paul. At this time, we will begin our Q&A session. During the webinar, we received a few questions, actually during the registration period as well as during the webinar. So we'll take that time to have some of those questions answered. But if you have additional questions while Paul is responding to these, please feel free to submit additional questions as the discussion continues. So I'll go ahead and kick that off with the time we have left to get a few questions answered. So Paul, we'll start out with this one. I know you kind of answered this a little bit more around enforcement, but I guess related to that, who regulates GDPR compliance for U.S. companies?
It kind of depends. If you are a U.S. company that has a physical presence in the EU, then the country where you have that physical presence or the country where you do most of your business will be your regulatory body or your supervisory authority, and that's who you will have to register with. Now, if you're a U.S. company who does business in the EU, but you have no physical presence over there, then the Federal Trade Commission is going to be the de facto supervisory authority for you.
Thank you, Paul. That helps. Here's another one that's it kind of builds on, I think, some of the presentation as well as what are the GDPR restrictions on employee data?
In GDPR, employee data is classified as special data. There are a number of reasons for this. One is some of the data can be very sensitive. GDPR considers special data those things that can reveal anything about a person's sex, political views, health, anything that would be highly personal in nature. And a lot of employee data contains elements of that. And because of that, GDPR states that you cannot use, as an employer, you cannot use consent as your basis for processing. That the employer-employee relationship is such that it can be viewed as kind of a forced consent. Well, you know, if you won't give us all this information, you know, we'll get rid of you or we'll fire you or, you know, we won't promote you or whatever. And so it becomes very important for employers, particularly if they're dealing with human resources data on anybody in the EU, that they state very clearly up front, here is all the data that we collect about you, and explicitly, here are the purposes that it's for. Again, GDPR goes back to saying you can collect this data, but you are limited to only that data which can be used for the processes that you have to do. And so if you're collecting things that are kind of beyond that, it may not be a good idea to keep those. But certainly notify your employees and let them know what data you collect and why you have to collect that.
Thank you, Paul. That's definitely helpful as well. This is one, this next question I know has come up even internally. I know we've had some discussions around it, so I'll throw this out here. What is the difference between an ability to directly identify an individual versus indirectly identify someone when it's as it pertains to GDPR?
In the U.S. in particular, we're very used to directly identified. That's things like name, address, social security number, etc. Indirect identification, though, refers to those pieces of information which, while by themselves may not uniquely identify a person, if built in conjunction with other data that you may gather or have, can be used to identify a person. For example, in the U.S., we do not consider a person's IP address to be personal data. In the EU, that is considered to be personal data. Classic case of why that's considered the way it is in the EU can be viewed through an example that was given several months back on how to identify data. Which is basically, if I go into a coffee shop in Paris and I buy a cup of coffee and I pay with my credit card, well, that credit card number can be used to directly identify me. So that's a case of direct identification. Now, scenario number two, I go into that coffee shop and I pay with cash. But I also give them a coupon that was sent to me via email to a blog that I run because I'm a real coffee aficionado and I blog about all the different coffee shops in Paris and so on. And so this was sent to me via a direct marketing campaign. Well, in virtually all those cases, there's some piece of information on there, usually embedded in a QR code or something like that, that can be used to uniquely identify me. So if you just look at that paper coupon, it doesn't tell you anything. But when you take that paper coupon and you actually go and you scan the code that's on it, all of a sudden you have my information. So that paper coupon becomes something that's called indirect identification, because while it may not have anything in and of itself that is directly identifiable to me, the fact that they have information on there that they can now go back and say, okay, we've got this code number goes back to this email, and so we know who that belongs to. And so they've linked that back, and now you have an identifiable stream. Now, if I just go in and pay with it with cash, it's still anonymous.
Okay, thanks, Paul. No, that's interesting. So I've got a question that came in, and I'm gonna. I think so. We talked a little bit about the data protection officer role, but there's mention that the question is around a data controller. So really asking the question of the role of a data controller and its applicability to GDPR. Is it a single data controller, or if you have an organization that has multiple business units, is that at a business unit level, or in even a finer granularity of those data controllers? So I guess defining that role and how that plays into GDPR, and do you need multiple? Is it by department? Is it for the overall organization? How does that work?
Well, the role of the data controller is really the legal organizational entity that pulls this personal data in for whatever use they're going to be using it for. And so it really resides more at a corporate level. GDPR makes a distinction between what they call a data controller, which is that entity that is actually gathering the data, that is deciding what they're going to do with it, and then doing processing based on those decisions. The other role in this is what they call the data processor. Now, the data processor will be something like maybe your third party, your cloud provider, who you have entrusted with this data, but you have told them these are the things that, this is how it's going to be processed. You have to process it this way. A real good example would be a company that collects all sorts of data for marketing purposes. Well, they may not have facilities in their organization to do all of the necessary data analytics. And so they will contract with a third party to actually do the analytics. But they tell the processor, this is what we want. Only do this. And that's all that the processor can legally do. Now, if the processor decides at some point in time, hey, I got a lot of cool data here, I could probably do some additional research. Well, the first thing they've got to do is get permission from the individuals. And the instant they do that, the instant that they take, that they move outside of the boundaries of what their limitations were as defined by the people that they were working for, all of a sudden they become data controllers because now they're making decisions about how the data is going to be processed. So as long as they're processing it strictly according to what the data controller said, they're a processor. And while they still have to comply with some elements of GDPR, it's not quite as exhaustive as it would be as if they were a controller. The instant you become a controller of data, then you are subject to everything that's in GDPR.
All right, no, great. Thank you, Paul. Well, I think with that, I think we're out of time for additional questions. So we'll go ahead and wrap up. So I want to thank everyone for joining us today. You will receive an email with a link following today's webinar with the webinar recording and a copy of today's presentation. Where you're still looking for GDPR compliance, guidance and requiring assistance developing your IT security strategy, please reach out to our certified experts at Acadata Systems. We are an industry leader in security with a 92% customer retention year over year over the last 5 years. And we'd be happy to start with a complimentary consultation. My email will be included in the resources provided after the presentation, so feel free to email me directly with any questions or requests. Thanks again.
Yes, I believe the slides will be made available with the link.
Yeah, no, that is correct. So,
yeah.
So with that, though,
cool.
Everyone have a great weekend. Thank you very much for joining.